Welcome back to the OMB Law Board. I'm Simon Bennett, and today I've got Family Law Partner at OMB Solicitors, Abbi Golightly. Welcome, Abbi.
Welcome. Thank you, Simon.
Well, thanks for being back as part of this family law series. Family law disputes can be really acrimonious, and does mediation work? Can talking resolve anything?
Yes, family law can be acrimonious, but it doesn't have to be, and that's the key. And that's where dispute resolution in its many and varied form in family law can give people the opportunity to regain control, and it's control over effectively their future. And so it can resolve matters if you want it to.
But what if the other party just wants to fight? I mean, quite often there's so much emotion involved in family law. Does it still worthwhile?
Not only is it worthwhile, it's mandatory. So there are very, very limited exceptions to the requirement to participate in dispute resolution. It's contained in the new central practice direction that commenced in 2021. That is a requirement to participate in dispute resolution through any of the various forms that exist. And one of the things that's contained within the OMB Family Law Welcome Pack that I send out when we receive contact from clients is a summary of the various different dispute resolution methods that can be used in family law matters. There is your standard mediation, what people would commonly associate with mediation. So sitting around a table and everyone talking, although we never sit around the one table.
Okay.
So it's usually run in what we call a shuttle style, whereby my client and myself and a support person, because you can bring a support person along as well, will be together. The other party and their representative would be together, and the mediator shuttles between the room, hence the name shuttle mediation.
So that gives me a little bit of separation, that if it's awkward or a little bit acrimonious, as I said, we could be in separate rooms and we're not having to face each other the whole day.
Exactly, because no matter how much you think you are past the emotional side of things, there wouldn't be anything enjoyable about sitting across a table from someone and them telling you all of the things you did or did not do during a relationship, because their perspective is invariably different than yours. So that gives that separation, and it also assists when there is circumstances of domestic and family violence, so that victims aren't being put in the same space as the perpetrator of domestic violence, which is really important.
Yeah, that's super important. And tell me, what are some of the benefits of mediation over the other methods that we use?
Sure. So mediation, I always liken it to my client. With my clients, I talk about control. You are regaining control of your outcome. You are regaining control of your life, and you are directing your future. Mediation enables us to be a little creative. So mediated outcomes can be very different to court-imposed outcomes. In the court system, litigation at the end of a trial, the court will say, this is the outcome, X, Y. You do this, you keep this, or you sell this. Mediation gives you the capacity to be creative. So instead of having to come up with X dollars within 30 days, you and your former partner could agree on, look, can't do it in 30. And in fact, wouldn't it be better if we kept the house, for example, for say 12 months because the market's going great? Why don't we treat it as an investment?
Yeah.
A court won't do that, but mediation will do that.
Okay.
It gives you that control.
So what I'm hearing is that there's more flexible outcomes, there's more options available to you, and if you choose to reach a result at mediation, you've got control over the outcome.
Exactly. Family law by its nature is a discretionary area of law. So we don't have a formula. It's not 15 years, 3 kids, pump it in, X outcome. It is discretionary. And so I say to clients, you put your same fact scenario before 10 different judges, you'll get 10 different outcomes, and pretty much 10 of them will be right.
Okay, well that's that's something that's really interesting. I understand there's 2 different types of mediation. Is there private mediation and court-mandated mediation? Could you explain to me the difference and explain to our viewers, how they both work?
Absolutely. So The expectation is to participate in dispute resolution before you approach the court processes. So it is a mandatory step that is required to be taken except in certain circumstances. And so that is what we call private mediation. So that is where you and your former partner and your lawyers attend mediation with a privately appointed mediator. They are usually legally trained mediators. Sometimes there are social workers that mediate in the parenting space, but generally speaking, your property settlement mediations will occur with a legally trained mediator. You engage them and you attend. You come to our offices. We hold a lot of mediations here. It's a great space for it.
Yep.
And you sit with the mediator and you talk about the outcome. And then if you reach that agreement, you decide upon the documentation of it and how that goes about. So that's before we even get to the court. If we try that, it doesn't work and we still end up in litigation, or if for any reason we can't do it beforehand, the court will, on its first return date, say, okay, what's our dispute resolution step here? And we discuss the different methods. Sometimes the court will say, off you go to private mediation, you have the financial capacity to do so. If you don't have the financial capacity to do so, the court will consider allocating what's called a conciliation conference, and that is the court-based dispute resolution process for financial matters. And then in parenting matters, it's a family dispute resolution conference through the court with a judicial registrar and often a court child expert sitting in as well. And at that point in time, you participate in the conciliation conference or the dispute resolution conference with children's matters. And if you reach an agreement, the judicial registrar is empowered by the court rules and the Family Law Act to make a court order then and there, and your matter is done on the spot.
Okay. Well, that's really interesting, and I'm sure our listeners and viewers found it interesting as well. Obviously, if there's any questions, drop us a comment. Please subscribe or like to our page because it's a big topic, and I'm sure there's a lot of questions that we could expand on with that. But
Absolutely.
Abbi, thanks for coming in today. We really appreciate it. Found that super interesting, and we'll see you again in the Family Law series.
Thanks, Simon.